Welcome back to LAWSTACHE channel. My name is Anton Vialtsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss what constitutes a seizure of a person under the Fourth Amendment, particularly in the context of vehicular stops. The reason why I picked this case was because of the events that led to the arrest of this particular defendant. Here, the officer did not pull over the car. Instead, after following the individual for about a mile and a half, the defendant pulled over to the side of the road, got out of the car, and opened his hood. Now, the officer then got behind the car, turned his lights on, and initiated the investigation into this particular individual. Eventually, the events led up to the search of the vehicle. But the defendant argues that that initial encounter without any reasonable suspicion already constituted an illegal detention or seizure under the Fourth Amendment. So before we go on and talk about what constitutes a seizure of a person and whether he's allowed to get all the evidence against him suppressed in court, I want to thank you for watching me on YouTube and hitting the subscribe button, sharing my channel with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and purchase one of my t-shirts, like the one I'm wearing right now, the Do Not Arrest This Person t-shirt. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vialtsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we'll be discussing a Ninth Circuit case, United States v. Chan Jimenez, and it deals with a seizure of a person. But first, let me give you some factual background. An officer was driving an unmarked pickup truck on a State Route 86 in Arizona. He observed another pickup truck that appeared dusty and had a tarp over its bed. According to Officer Price, the truck didn't appear to belong in the area, even though the driver of the pickup truck was driving within the posted speed limit, did not violate any traffic ordinances, and neither trucks nor dusty vehicles are particularly unusual in the area of the Arizona desert. The officer then ran the license plate and figured out that the truck was registered to Mr. Chan Jimenez. The officer drove behind the truck for about a mile and a half. Eventually, Chan Jimenez pulled over to the side of the road. Him and his passenger got out of the truck and lifted their hood. The officer pulled over behind the truck and activated his emergency lights to indicate that he was a police officer because remember, he was driving an unmarked vehicle. He then approached Mr. Chan Jimenez and also told him that he was a police officer. He identified himself as such. The officer then requested Chan Jimenez for his driver's license. Mr. Chan Jimenez gave him the driver's license. The officer asked whether the truck belonged to Mr. Chan Jimenez. Even though he already knew the answer, that it was registered to Mr. Chan then told the officer that the truck was in fact his. At no point did the officer inquire whether Chan Jimenez was experiencing any problems with the truck. He asked Mr. Chan Jimenez for the registration and license, and all of those pieces of information were in order, all of those documents. Instead of asking Mr. Chan Jimenez about the truck and whether he needed any help, officer asked whether he could conduct a search and look in the bed of the truck. Officer Price had his hand on his revolver at the time, did not inform Chan Jimenez that he could refuse to consent, and did not offer the return of papers. Remember, the registration and driver's license. Mr. Chan Jimenez did not verbally consent to the search, but instead he walked to the back of the truck and lifted the tarp. under the tarp, there was 245 pounds of marijuana. The officer then arrested Mr. Chan Jimenez. He was later charged with possession with intent to distribute in federal court. He argued for the suppression of the evidence, the suppression of the marijuana that was found, because he said that the initial detention was in violation of his Fourth Amendment rights against illegal searches and seizures. But first, let's discuss what constitutes a seizure under the Fourth Amendment. For the purposes of the Fourth Amendment, a seizure occurs when law enforcement officer, by means of physical force or show of authority, in some way restrains the liberty of a citizen. A police officer has restrained the liberty of the citizen if, by taking into account all of the circumstances surrounding the encounter, the police conduct would have communicated to a reasonable person that he was not at liberty to ignore the police presence and go about his business. The Ninth Circuit finds that Chan Jimenez was in fact seized within the meaning of the Fourth Amendment. The officer obtained and failed to return the driver's license and the registration back to Mr. Chan Jimenez and proceeded with his investigation when law enforcement takes those important documents and retains possession of those documents longer than necessary to ascertain whether they're valid and whether everything is in order. That would indicate a seizure under the Fourth Amendment. The court also says the fact that the officer had his hand on his gun also indicates a seizure, because no reasonable person would think that they would be free to leave from that type of encounter. No person in their right mind would think that they can drive off without their documents and with the officer having his hand on the gun. For those reasons, Mr. Chan Jimenez was in fact seized under the Fourth Amendment, within the meaning of the Fourth Amendment. Now the court proceeds to look at consent, whether Mr. Chan Jimenez consented to the search of the truck. Naturally, if we have a violation of the Fourth Amendment, like we do have one here, the officer, without any reasonable suspicion or probable cause, detained and seized the person, all the evidence that's followed should be suppressed under the fruits of the poisonous tree doctrine. But the court still goes on and talks about consent because in rare circumstances, consent can still be valid. So let's go ahead and talk about what constitutes a valid consent under the Fourth Amendment. In order to establish the validity of a consent to search, the government bears the heavy burden of demonstrating that the consent was freely and voluntarily given. Among the factors that tend to show a lack of voluntariness are: number one, the person was in custody; number two, the officer had his weapon drawn; the officer failed to administer Miranda warnings; number four, the officer did not inform the person of his right to refuse to consent; and number five, the person was told that a search warrant could be obtained. Here, the Ninth Circuit already determined that Chan Jimenez was in fact seized. Here, the officer also did not give him the Miranda warnings, did not inform Chan Jimenez that he had a right to refuse to the search, and even though no guns were drawn, we do have a fact that officer had his hand on his gun during the encounter with Mr. Chan Jimenez. All of those reasons show that this was not a valid consent. And the court moves on and tells us an additional fact, that under certain circumstances, a non-verbal compliance can show consent. But here, the fact that Mr. Chan Jimenez just walked around and without saying yes lifted the tarp does not show that he unequivocally consented to the search. It might have been simply a compliance because he's being detained and there's a hand on the gun that the officer had. For all of these reasons, there's not a valid consent in this case. In conclusion, we know that the police officer did not have reasonable suspicion or probable cause to seize Mr. Chan Jimenez, and the consent that was provided was not valid, which means that all the evidence, namely the marijuana, must be suppressed and cannot be used against Chan Jimenez in court. But here's the big takeaway. When law enforcement retained possession of personal identification documents longer than necessary to ascertain whether everything is in order and continue with their inquiry and investigation, that constitutes an illegal seizure under the Fourth Amendment, because no reasonable person would feel free to leave in that situation. I hope you enjoyed this video. I hope you learned a little bit more about seizure of a person under the Fourth Amendment in the context of vehicular searches. If you like this video, please give it a thumbs up, subscribe to my channel, and share it with your family and friends. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and purchase one of my t-shirts, including the one that I'm wearing right now, the Do Not Arrest This Person t-shirt. Thanks for watching.